very much for coming this evening. It actually looks like quite a nice evening, so you might have contemplated doing something pleasurable for the first evening of spring. But instead you have elected to come and listen to, I think, one of the, an old friend of mine, Professor Bernt from the University of Amsterdam. But he is not just a good friend, he's one of the most important figures in intellectual property in Europe and therefore the world over his career. He has written substantially, as many of you will know, particularly on copyright, but also more broadly on information issues. He was for many years after the passage of the EU Database Directive self-evidently the leading figure commentating on this directive. And subsequent to that, he was the founder of some very important copyright initiatives in Europe, in which I have had a lowly role, and Bernt has been the initiator. The first was the VISM Code, European copyright scholars formulating a European copyright code. And then, after the VISM group came to an end, Bernt founded the European Copyright Society of copyright professors from all over Europe that has taken an increasingly prominent role in trying to shape copyright policy in Europe, both through judicial fora and through intervention in legislative processes. Is that enough?
No, you've sufficiently embarrassed me. Yes.
Yes. Let me say also add that a few years ago, and I ought to check this, Bernt was our annual intellectual property speaker at Emmanuel College, and he did a fantastic lecture then. And we are happy to have him for a month as a Herschel Smith visitor. So he is around and therefore capable of being badgered. But whether you want to badger him will probably depend on what you hear now, which I think will be stupendous. So thank you, Bernt.
Well, thank you for this totally over-the-top introduction, Lionel, and for overstating my reputation and underselling your own. Thank you in particular for this invitation to give a talk here, and for the hospitality I've already received here in Cambridge. I am indeed here until the end of the month, enjoying the polar weather. Well, it got a little bit better now, which is very good for studying, which of course is the main aim of my visit here, and talking to as many academics as possible and students. What I'm going to talk about today is one of my research interests currently. As Lionel mentioned, database protection has been an interest of mine for many years. I'm not going to talk about database protection today, although a superficial glance at the title of my talk would suggest otherwise. This is about data protection, data property to be precise, not personal data protection, but about a right that I think fortunately does not yet exist in Europe, but which might be introduced in the years to come if the European Commission gets its way. A novel property right in non-personal machine-generated data, also known as data producer's right. Again, this is not in the books yet, it's not been codified, there's no directive that you have overlooked. But it might become there, and if so, I think we're in serious trouble. I'm anticipating my conclusions, which I will present to you much later. Where does this story start? It starts here. About a year ago, the European Commission published one of its many policy papers on the digital single market, a policy paper that you might have overlooked amongst all the many other Brussels papers, maybe also because you think that whatever comes out of Brussels these days is of no concern to you. since you're out of Europe soon. You will not have your data producers, right, if it ever happens. You might have also overlooked it because it's not a typical IP paper. This is a broader policy paper that discusses a future data economy. Well, a data economy that's already emerging and that the European Commission believes deserves various forms of oversight and regulatory intervention. It's a very interesting piece of work that touches on a lot of things related to the data economy, not just the data producers, right, that I will be talking about today. The paper starts with a picture of a marvelous future that is already in the making, where the data economy, as the European Commission calls it, will produce enormous economic welfare for all Europeans. The data economy, as it is described in this paper, I quote now, is characterized by an ecosystem of different types of market players, manufacturers, researchers, infrastructure providers, collaborating to ensure that data is accessible and usable. This data economy in size is estimated by the EU, doesn't say how it estimates this, at tremendous amounts of money, 257 billion euro calculated in 2014, rising to 643 billion euro by 2020, representing 3.17% of the overall GDP in Europe. Colossal figures. Clearly the data economy, however you define or measure it, is very important and will be even more important in the years to come. What is this about? This is mostly about the reuse of machine-generated data. And while that sounds abstract, you will immediately relate to it perhaps when you see this slide. This is about the Internet of Things. The Internet of Things, the things we use in our daily life, the machines we work with that manufacture other things, all are interconnected or are increasingly interconnected, and in this process produce vast amounts of data. Data that have value not only to the manufacturer and the user, but also in aftermarkets. And it's about those aftermarkets, those secondary markets, that this paper is really concerned with. Things like your bike, important vehicle here in Cambridge, I noted to my satisfaction, but also airplanes, and particularly, well, the proverbial refrigerator should be there as well. The refrigerator phoning to the Tesco, telling the Tesco that it's empty, or, well, you can tell a little story with each of these things. Here, the most important thing, definitely, in the communication and in the whole policy issue that I will present to you is the car, the automobile. The automobile that in recent years has turned into a vast, in a large data producing machine. This is from a recent post on the CNN technology page. The most valuable thing about tomorrow's car is something you'll never even see: data. The story suggests that the data that the car produces in driving and navigating will have much more value, perhaps even than the car itself. Automobiles will play a central role in this story, as I will demonstrate. But there are, of course, many other kinds of data that this data economy is concerned with. Here's some other examples of machine-generated data. the engine performance data of a car, obviously, or of other machines. These have value, for instance, to the garages or other repair centers that live off car repair. Navigation data generated perhaps by a traveling automobilist or anyone else using navigation devices has value for Google, for the municipality of Cambridge, for traffic controllers, for many other users. Remote sensing data, search engine data, stock market data, energy consumption data, climate control data. The data of our Spotify behavior, audio and video data usage from Netflix, biomedical data produced by health appliances, pharmaceutical research data. A lot of these are machine generated. A lot of these have increasing value. This is what we're looking at in the context of this policy initiative. So where does it become really interesting for our story? The European Commission in its policy paper sketches a variety of ways that the market for secondary machine-generated data might be fostered. A large part of the document is about creating and facilitating access to data held by private parties. Think of the enormous amounts of data that Google is sitting on. Wouldn't other commercial players like to have access to these data? Think of the data an automobile manufacturer controls. Wouldn't other manufacturers, wouldn't the repair industry like to have access to those? But then comes the really interesting part. Apart from the variety of access rules that you could imagine, suddenly the European Commission comes up with the idea of introducing a right that would actually create property rights in these data. A data producer's right, a right to use and authorize the use of non-personal data, I'm quoting from the paper here, could be granted to the data producer, says the Commission, i.e. the owner of or long-term user, the lessee of the device. This approach, says the Commission, would aim at clarifying the legal situation and giving more choice to the data producer by opening up the possibility for users to utilize their data and thereby contribute to unlocking machine-generated data. So in this section of the communication, the Commission floats the idea of introducing a property right, creating a property right in machine-generated data to foster the secondary market. Whether that's a good idea, we'll come back to that, but this is where it comes from. What kind of data would that be? The Commission in its communication is very, very concise in describing it, but in an accompanying document, which is much thicker, a so-called staff working document of the same date, the 10th of January of last year, this data producer's right is given some substance. This is the way the Commission suggests the data producer's right would look like. It would be a right in non-personal or anonymized machine-generated data. So we're not talking about a right in personal data here. The Commission is very careful in distinguishing this right from a right in personal data that is evidently already covered by a whole variety of directives on personal data protection, including the recent GDPR, the regulation on personal data. So it keeps that out of the picture. The right in question here, this right in non-personal machine-generated data, would entail an exclusive right to utilize certain data, including the right to license its usage. So it would be an exclusive right, similar to intellectual property rights. It would also be fully transferable, similar to IP rights, to most IP rights. And although the Commission itself is rather ambiguous about its designated right owner, it's clear that what the Commission believes would be the right holder is the economically responsible operator of equipment that generates the data, the so-called data producer. This quote is not from the Commission's staff working document. It's actually from a German scholar, Herbert Zeck, who has been very important in providing the thinking underlying this data producer's right. The Commission officials have obviously talked to Professor Zeck, or at least read his Habilitationsschrift, which is information as a object or subject matter of protection, Information als Schutzgegenstand. I'm sure you've all read that and probably read it again in preparation of this meeting. It's a very interesting book, monograph that looks at various ways of protecting information. And in this book, he also suggests the idea of a data producer's right. He is quoted extensively in the Commission's document. So Herbert Zeck is very much behind this, but even more so, this other, much more famous or German, Günther Oettinger. Günther Oettinger is the, and you've seen his name before, is a commissioner, one of the commissioners at the European Commission. Until the 1st of January of last year, he was in charge of DG Connect, and therefore responsible for this initiative of building a data economy. He's been pushing this idea of a data producer's right, or Dateneigentum, as he calls it in German, at various levels, and successfully so until now, with the result that it's now official Commission policy. Most likely, he has been doing so at particularly in the interest of the European automobile industry. You see him here in a BMW. I'm not suggesting that he was given that BMW, but he certainly has close connections to the automobile industry in Germany, who have been pushing this idea of a data property. But let's not make this into a personal story. Why would the European Commission want to create, why would anyone want to create such a right? You may have been wondering now for quite some time. What are the arguments in favor of such a right? The communication of the Commission presents actually only one argument, which you may or may not find convincing. The argument that I already briefly quoted, that creating a right in machine-generated data would foster the aftermarket, would foster the data economy, would make it easier to reutilize and trade machine-generated data between private parties by creating a tradable right. This is a classic economic reasoning. Create a right which can then be traded. according to the Commission, it's not really creating a right, it's creating legal certainty regarding data ownership. The Commission doesn't say that we already have such a right or not. I think we don't have it. But anyway, by creating such a right, the right would become better tradable, suggests the Commission. I quote, enhancing the tradability of non-personal or anonymized machine-generated data as an economic good. So that's the main reason why the Commission suggested, but I can imagine a few other reasons, somewhat related reasons, somewhat unrelated. Another reason, and this is, I have derived this one from conversations with the European Commission. I've been trying to talk the Commission out of this idea, and in these conversations, I heard this one. Wouldn't it be great for consumers who use these intelligent devices that are all interconnected and that produce vast amounts of data to actually have a property right in these data, which they can then use as a tradable token in their dealings with the consumer electronics industry? They could exchange their right in these data for a rebate, for discounts, or for other perks. They would not be robbed from their data without any compensation. So there the idea is give consumers a property right so they can stand up against the industry. We've heard that argument before in the context of personal data protection. It's a bit similar to that. And then there's a third argument, which you will not find in the communication, but which is clearly behind this story as well. The fear of major industry players in Europe that we Europeans will get robbed of our data by the Americans, particularly by Google, or if not Google, by Uber or Tesla, or anyone else developing self-driving cars. For self-driving cars, we need lots of data. These European automobiles produce lots of data. We should keep these for ourselves, for our own industry, not give them away to the Americans. This is an argument that resonates, again, in informal discussions with the Commission, but it's clearly also an argument that can be found in the German discourse that anticipates much of this. I started my story with the EC's communication, but there's an older story to be told from Germany. In Germany, this discussion has been ongoing for several years. And there you clearly see fear of Google, fear of Tesla as a driving agent in this discussion. If we frame it that way, this idea of a data producer's right is akin to a right that conceptually also has something in common with this right, the idea of a neighboring right in online news. That's another right that we as yet do not have in Europe, but this one is really happening, unfortunately. This is part of the proposal for a DSM directive. I'm sure many of you heard about it. It's been thoroughly examined and criticized by Lionel and his institute. Here too, as one of the arguments for introducing such a right, you see this same argument, fear of the Americans grabbing our news in this case. Then there's a fourth argument, more of a intuitive argument. Wouldn't it be great to establish a data property right where everyone in the industry already assumes that such a right exists? If you talk to people in the industry, data ownership is already, or data property is already a given almost. It's part of contracts, it's mentioned in this, who owns the data? We own these data, we own vast amounts of data. The whole idea that data are already owned is pervasive in the industry, not only in the industry, I'm afraid in science as well. Many people, scientists, believe the same. I do these experiments, I own these data. There's an intuitive, perhaps almost Lockean underbelly notion of ownership here. And this right would validate that. So you could say create legal certainty. Maybe this is connected to the first argument. So there are a couple of arguments here, and maybe there are others as well. We might discuss that in our Q&A. And they may or may not be convincing. They certainly are not convincing for the economists who have written about this idea so far. And there are a number of economic studies on whether or not we should introduce such a data property in non-personal data. I refer particularly to Professor Kerber from Germany. Professor Drexel and the whole Max Planck Institute have done a quite extensive study. And there's an even more extensive and more recent study by the European Commission itself, by its Joint Research Council, which I can also recommend. This is the broadest study so far, and it's done by under the control of the Commission itself. So it's really, from that angle, perhaps the best source to look at. All these economic studies are united in their skepticism about the need for introducing such a right. There's no evidence, say all these studies, of insufficient incentives to generate data. One of the classic reasons to introduce new IP rights, as we all know, is to create incentives and to overcome the public good dilemma, the tragedy of the commons. There's no need, there's no evidence as yet for such an incentive in the form of an exclusive right. There's also no evidence of transactional market failure requiring any legislative intervention to foster the tradability. I have not done any of these studies. I'm not an economist. I'm just relying on what I've been reading. So while there may be some political arguments and perhaps some more emotional arguments underlying this idea, the economists themselves so far are not convinced. But that's not what I want to talk about. What I want to talk about, of course, is the intellectual property consequences of introducing such a right, the legal angle. That's where my competence lies, and that's what I want to talk about for the rest of this presentation. How would such a right, if we have it, how would that interact with existing systems of intellectual property? Would it make sense conceptually from the perspective of intellectual property to introduce such a right? Let's first look at existing IP law. What do we have in terms of protection of machine-generated data? What do we have in the books? Well, there are a number of regimes that immediately come to mind. Copyright. Isn't copyright already a useful vehicle? Well, no. We have an originality requirement, a requirement of creativity that clearly militates against protecting machine-generated raw data. Creative compilations of data reflecting the personality of its author, or at least some skill and labor. Yes, they might qualify, but vast amounts of machine-generated raw data, clearly not. There's a general rule, and it's a very important rule that we should not overlook, that copyright does not protect facts, data, or ideas. This is the idea-expression dichotomy, lesson number 1 in the copyright, in any copyright course. Facts, etc., are or should remain free as the air for common use. Famous quote from Justice Brandeis from the Supreme Court in the US a long time ago. We do have a database right already mentioned, the sui generis right that protects outside of the framework of copyright databases, structured data collections defined in the directive as requiring some structure. These might protect collections of raw data structured and organized and presented in a database, but certainly not the machine data themselves. Apart from the definition of database, which is an obstacle to protection of raw data, there is the requirement of substantial investment in sui generis law. Many cases probably not met by machines generating data more or less automatically. On top of that, there is this rather difficult to fathom created data doctrine that also rules out investment in synthesized data. So there are a number of reasons under the database right that also lead to the conclusion that there is no protection for machine-generated data per se, neither under copyright nor under database right. But there might be protection, and there probably is quite a lot of protection available under other doctrines. And this is something that the Commission somewhat overlooks in its communication. Other doctrines, such as factual possession, although not conceptualized as a property right, can actually create the leverage and the basis for potentially a healthy trade in data. Factual control over the medium of storage is the starting point of any transaction. On top of that, this factual control can be strengthened by technical protection measures, by access controls or copy control mechanisms. And on top of that, a layer of contract can be fashioned. So you can actually have quite a lot of protection for your data, even if you don't rely on a data property right as emphasized by the Commission. And then there's the protection of trade secrets, which is certainly not new to you here in the UK, but is a new and evolving doctrine in most of Europe, where we now have the Trade Secret Directive in the books requiring trade secret protection across Europe. In the Netherlands, where I'm from, we are implementing this as we speak. The Trade Secret Directive clearly aims at protecting information as long as it is kept secret, and that also has a lot of potential for protecting data in data transactions, as long as the data are kept confidential in some way. On top of that, some countries have developed doctrines based on general criminal or civil law principles. I'm not a big fan of these theories, but I have seen them in France, in Germany, in Italy, in Spain, where data theft could be actionable under criminal law, where, according to some civil lawyers, data ownership based on traditional ownership, property in tangible goods, may be extrapolated. I don't really believe in these doctrines, but that's also because I'm an information or intellectual property lawyer. I'm not very sympathetic to this idea of stretching these general doctrines into the realm of the intangible, but they are there, and certainly also in Germany, where we've seen a lot of discussion about this. And then there's data protection law, not data producers, right, but good old personal data protection law as enshrined now in the GDPR, which is at least in Europe is making an enormous impact. Now, machine-generated data, as the European Commission sees them, are not personal data. But if you look at the definition of personal data in the GDPR, it's extremely expansive. And it could actually cover a lot of the data that the Commission believes are non-personal. Look at the definition here, if you don't already know it. Article 4.1 of the regulation. Personal data means any information relating to an identified or identifiable natural person. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, identification number, location data, online identifier, or to one or more factors specific to the physical, psychological, blah, 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 blah. It's very, very, very broad. A lot of these navigational data, for instance, might qualify as personal data. A lot of the health data we're looking at, most likely as well. So there is, in fact, quite an extensive amount of protection available under law or under de facto possession. Here's another argument against introducing a special right. We've already seen there's no real need. We've seen that there is already some protection available. From the IP perspective, a data producer's right would, I believe, severely disrupt our present system. Consider having a data producer's right next to, for instance, the existing layer of copyright that we have. A simple example would involve the making of a movie through a digital camera. That is a machine. The machine produces data. The data are the data that represent the film, the video. So what we would have, if we had such a right, we would have side by side a copyright of the film author, or multiple authors usually, and a data producer's right of the person owning the camera or controlling it or leasing it or all of the above. I'm sure Hollywood, or at least the European variants of the film industry here in Europe, would not be happy with that idea. More generally, this right would totally overlap with all forms of creation involving machines, particularly digital machines. And it's actually hard to imagine examples where it would not overlap. We have entered a world where all creation almost involves some form of digital device. So these extra layers of IP protection would obviously lead to immense transaction costs, unnecessary transactions costs, possibly even license tickets that from an economic perspective would be very harmful. It would also, and I think that's a more serious objection, undermine the existing, presumably balanced system of copyright that protects but also leaves free certain uses. The data producer's right would endanger that by creating a top layer that would disregard these exceptions unless we repeat all these exceptions and limitations at this higher or lower level of the data producer's right. I'm also not so sure that a data producer's right would really do anything for legal certainty. This is what the Commission believes it would, but my opinion is quite the opposite. I think it would severely undermine legal certainty. For one, because the subject matter of the right would be highly uncertain. What are the data that the machine produces in a world where, in a situation where the machines are constantly producing new data? This is the velocity problem that some other authors have also pointed out. Data are generated usually in real time. The data, it's very difficult to identify which data at a certain moment are there. There is no stable object, in other words, of protection. That in itself is a reason not to grant an IP right. On top of that, the ownership issue raises additional uncertainties. the Commission is vague about who should own this right. Would it be the user or the operator or the owner of the machine that generates the data, or possibly even both? Well, even if you choose amongst these different candidates, what is operating a machine, where machines operate almost by themselves, autonomously? Speaking of BMW, if you've ever been to the BMW factory in Munich, there are no people there. There are some people sitting in offices, but for the rest, there's just robots and machines, and that's probably true for a lot of other manufacturing plants anywhere in the world these days. Who is operating those machines that generate the data? So allocating the right would be extremely difficult. Now, at a more principled level, I believe we should not go down this road for a very different reason. Introducing such a no threshold right, a right that arises automatically by creating data, even if those data have some economic value, I believe the whole idea of intellectual property would be severely undermined. Its justifications and incentives are based on certain rationales. Copyright rewards and promotes cultural expression. The database right, even if we don't really like it, rewards and promotes investment in data production. So it has a certain function, it rewards merit, and it acts as an incentive. This right is based on no merit except for a machine that's running anyway. There's no need for an incentive here. I believe if we have such a right, it would call the legitimacy of the entire system of intellectual property right seriously into question. So it would really hurt IP and its legitimacy, which is already fragile, to say the least, in political contexts. Another more principled objection is that such a right undoubtedly would impede the free flow of information that the Commission wants to foster according to its communication. This right would inhibit directly freedom of expression and information, which certainly includes the freedom to exchange data. Also inhibit strongly freedom of competition. I must mention here, of course, Article 10 of the European Convention on Human Rights, from which you are not yet Brexiting, I hope, or maybe you are. According to Article 10, the freedom of expression, restrictions to freedom of expression and information must be necessary in a democratic society. There's no proof at all that this data producers' right is necessary in a democratic society. Quite to the contrary, data ownership of any form would, in my opinion, severely affect these freedoms, particularly scientific freedoms. It would also conflict, strangely, with other EC policies by the same directorate, advanced by the same Directorate General on open data. The European Commission is a big fan of open data. It's also proposing an exception on text and data mining, allowing non-commercial research entities to engage in unauthorized data and analytics based on copying large amounts of text and data. Introducing a data property right, a data producer's right, would be totally in conflict with that idea. So, in sum, lots of reasons not to like this idea. Is it going to happen? Where are we now? The consultation, which was conducted after the communication, you can see the results on the European Commission's web pages, reveals a certain skepticism amongst stakeholders. Consultations are always amongst stakeholders. Unfortunately, they're never amongst people who really know what they're talking about, like academics. So even the stakeholders are skeptical, which is, I think that's almost evidence of the fact that this is a really bad idea. The stakeholders are afraid that creating a data producer's right would undermine, as I mentioned earlier, the developing data market that the stakeholders would like to see happen, obviously. So the Commission is not proposing this new right in any more recent document. The free flow of data regulation that you may have also overlooked does not even mention it. This is a regulation, a spin-off of the communication involved concerned only with preventing localization rules in respect of data control and data processing. There's nothing in there proposing a data producer's right, so that's good news too. However, the European Commission is still working on this Building a European Data Economy initiative. It's far from over, and there's more expected soon, in spring of this year. Perhaps a proposal for a directive, perhaps only guidelines, we don't really know. We also don't know what will be in this initiative. My guess is, given the strong criticism that this idea of a data producer's right has attracted, that the main focus of the remaining initiative will be on access to privately held data rather than on creating data property rights, but we're never sure. Well, speaking of access, it's also not clear what kind of rules that might entail. Perhaps forms of self-regulation, if I may guess again. And then there's another initiative, and our host, your host, Professor Lionel Bentley, knows much more about this than I do. Then there is the ongoing review of the database directive. The database directive, that's not concerned currently with protecting raw data as such, but it could be expanded, and it would actually be a natural thing if the European legislator wants to create this right to include it in the directive, which is already an intellectual property instrument. You would only need to change the definition a bit, remove a few elements, and you're there. Could be that that's the plan, that the European Commission is going to introduce it there, but I have no evidence of that going to happen. I also don't know where the review currently stands. We could ask Professor Bentley about that. In sum, it's not there yet. It might never happen. If we all agree and if we all tell the rest of the world, it will never happen. On the other hand, we should not estimate the powers that be, the automotive industry, Commissioner Oettinger, and the European Commission at large. This is the end of my talk, but I'm open to discussion, although I have already formed my own opinion, clearly.